The D.C. Court of Appeals strikes down the district's 10-round magazine limit. Plus, gun sales surge in Virginia as state lawmakers weigh a gun control blitz. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over today to sign up for our free weekly newsletter. It'll keep you up to date on all things happening in the world of gun politics and policy. Kick things off for us this week. We had a little bit of, frankly, breaking news last night, right before we recording this on Friday. But Thursday evening, the D.C. Court of Appeals issued a ruling in a criminal case related to the district's restrictions on magazines, where, at least as applied to this particular defendant, they said that the district's limits are unconstitutional under the Second Amendment.
That's right. Pretty major ruling out of what is basically like the local courts for DC. I mean, DC is obviously a bit of a weird, unique area when it comes to this stuff, because they have their own federal district that's just for Washington, D.C., but then they also have a sort of local court system. And this is coming from the local court system, the D.C. Court of Appeals, which is the court of last resort there. So it's sort of like their Supreme Court. They don't have a D.C. Supreme Court. I mean, they have the United States Supreme Court, but they don't have a Supreme Court for the district. They have this Court of Appeals. And in a 2-1 ruling, they tossed charges against a man who was found with a 30-round Glock magazine and an unregistered firearm because they ruled that the magazine restriction is unconstitutional, that it violates the Second Amendment because those magazines are in common use, harkening back to the Heller standard here. But let me give you a quote from Judge Joshua Deal, who wrote for the majority in this case is called Benson v. U.S. And the judge wrote, quote, "Magazines capable of holding more than 10 rounds of ammunition are ubiquitous in our country, numbering in the hundreds of millions, accounting for about half of the magazines in the hands of our citizenry. And they come standard with most popular firearms sold in America today. Because these magazines are arms in common and ubiquitous use by law-abiding citizens across the country, we agree with Benson and the United States that the district's outright ban on them violates the Second Amendment." And one thing you can take away from that quote there is that the Department of Justice in this case actually ended up eventually siding with the defendant, Benson, and acknowledging that DC's magazine ban is unconstitutional, which was a change of position for the federal government here, because they had initially been the ones to bring this case against Benson, but had subsequently changed course and sided with him, arguing against DC's magazine ban that, comes as the DOJ's Civil Rights Division has filed suit against Washington, D.C. over its assault weapons ban as well, and is in line with similar changes we've seen from DOJ, especially in cases involving state restrictions, not necessarily federal restrictions, but state restrictions. We have seen them do this a number of times now, and I think this is, if not the first, at least one of the first times we've seen a ruling that came down around that position change. So it's a real world effect here, where this DC Court of Appeals DC Court of Appeals panel has now effectively invalidated the magazine ban in the district. Now the conclusion of this case, that they did find that the law violates the Second Amendment, but their conclusion is that this was an as-applied challenge dealing with one criminal defendant. And so the charges against him were tossed, but they didn't issue a ruling that forces, for instance, DC to stop enforcing this law, although effectively it will be difficult to enforce it under this precedent, obviously. But just to be clear, it doesn't literally strike down the law. It just throws out this guy's conviction.
Yeah, which is certainly a big deal, though. Nevertheless, even though it isn't, quite the sweeping lawsuit, blanket invalidation of a gun law, because as we've covered many, many times on this show and in our articles, it's just not super common to see hardware ban challenges these days, particularly magazines, it seems, end up in an outcome like this. And that's what also kind of makes the majority opinion in this case interesting, because it kind of goes almost argument by argument through those typical rationales that we've seen in many of these hardware ban challenges, talking about the common use for self-defense, where they add that, or judges will add that sort of extra layer and say, well, even if people use magazines and say it's for self-defense, they don't actually fire more than 10 rounds typically in self-defense encounters. And so it's all these different arguments you tend to see in these rulings actually get addressed in this particular ruling. And in this case, the judges say, no, those don't count as, rationales for upholding the law. It actually, it's still unconstitutional nevertheless.
Yeah, they went through all the common arguments we've seen in other hardware ban cases like this one, especially the magazine ban cases. I think the dissent here notes that this ruling is, different from what the other appeals courts, the federal appeals courts, but other appeals courts have found. I think there have been 5 federal appeals courts who've looked at these same sort of laws, and all of them have upheld the restrictions under, as you pointed to, a number of different rationales. The common use for adding the for self-defense standard to that, but also making that's the evidence that something is being used for self-defense. They're basing that around how often people say how many rounds they say they fire in self-defense encounters, which, of course, if you remember from William English, professor, I think he was Georgetown, if I'm remembering correctly. Apologize to Professor English. If not, he was on the show actually when he had sort of a landmark survey a couple years ago that asked self-defense questions to thousands of Americans across the country, and he produced results that have been cited a lot, including in this case, but also in a number of other cases where, he asked about how, people who own these magazines, but also about what people say they used, how many rounds they fired if they were in a self-defense incident. And of course, one of the interesting takeaways from that survey and many other surveys like it, is that mostly people don't fire any shots when they use a gun in self-defense. That I think it was something like 80% of people who say they used a gun in self-defense didn't fire a single round. But then the next most common is 1 shot and then 2 shots, and it gets less common from there, right? And so often you'll see that cited in these other rulings that uphold magazine restrictions, to say, well, people aren't actually using more than a couple of rounds in self-defense situations, so they're not actually using the full capacity of these magazines that are restricted, so therefore the magazines aren't in common use. It's sort of the court here called it a tortured logic, and it's essentially, it doesn't matter if people have 10, 11 round magazines and 11 plus round magazines in their guns when they're using them for self-defense. It only matters that the number of shots they've actually fired. So this court certainly rejected that standard. And then, you also will often see an argument that magazines aren't even arms under the Second Amendment. They're not protected arms. The right to keep and bear arms doesn't actually encompass magazines. This was something that came up in the Ninth Circuit in Duncan, which this panel directly deals with, and rejects, right, the idea that magazines, or at the very least magazines that hold more than 10 rounds, aren't protected arms. I'll give you a quote from the ruling. Judge Deal said, quote, on the district's logic, meaning the District of Columbia, who was still defending this law, states could ban 2 round or even 1 round magazines. There's no reason A semi-automatic firearm cannot fire with an empty or dummy magazine so long as there is a round in the chamber. In fact, under the district's view, the state could just directly outlaw the semi-automatic firing mechanism because by itself, that is a harmless component of a firearm and it is not a necessary feature of any gun. So, they're responding to this idea that magazines themselves are not arms, right? They themselves are not used for offensive or defensive purposes, right? They're not actually the thing that you send downrange, right? And therefore, they're not protected. This panel is saying that doesn't make sense, right? You could use this logic to ban almost any part of a firearm. In fact, here's a further quote. For that matter, modern cartridges are not necessary for firing a gun either. If the Second Amendment applied only to those things that are strictly necessary for a gun's operation, states could ban cartridges so long as primitive musket balls remained a legal alternative ammunition. So, essentially, completely rejecting the logic that we've seen other courts use to uphold similar restrictions. And I think I got the gender wrong here because I've said she, but Judge Joshua Deal feels like, yeah. Apologies to the judge here. I'll go back and make a correction of the piece to get his gender correct. But regardless, here was their ultimate conclusion. Quote, the more sensible view is that magazines of all sizes, like other core components of firearms, are arms that are covered by the Second Amendment's plain text as a threshold matter. Any components integral to a firearms operation, like magazines, fit comfortably within the Second Amendment's protection of arms. And then it went on to do the common use analysis, which we touched on earlier, where they said magazines that hold more than 10 rounds are among the most common kinds of magazines. And additionally, it rejected the argument that when the Supreme Court said dangerous and unusual arms can be banned, what they meant was just unusually dangerous guns. And that could be things that are popular. This court said, no, that doesn't work. Essentially, if guns are common, or they're popular, many people own and use them, arms, then effectively they're protected. And so ultimately, what ended up happening here too is because they rejected the constitutionality of this magazine ban, and DC does not allow you to register a gun with a magazine that holds more than 10 rounds. They also said that the unconstitutionality of this particular part of DC's firearms law infected all of the charges against Benson. And so even though he was convicted of not just having that magazine, but also that his gun was unregistered and that he didn't have a concealed carry license, they tossed those charges as well because they said, well, it's not possible with this unconstitutional ban on magazines for him to have gone through the legal process. And so all of these charges are effectively invalid against him. So pretty, I think, significant ruling out of the circuit here. I'm not exactly what comes next is a little bit unclear to me because we wrote about the federal counterpart to this lawsuit a couple years ago, where the circuit court, the federal circuit court in DC, upheld this same regulation. So it'll be interesting to see what the interplay is there and what exactly ends up being the practical outcome from this case, or what the DC's government can do here. I assume they can appeal this to the Supreme Court, although that's another question of whether they would even want to at this point, because DC has actually refrained from appealing. DC has lost a lot of these cases over the last 20 years, right? Going back to Heller was a DC case, right? DC had a total ban on handguns possession up until not that long ago, right? About 20 years ago, not even 20 years ago at this point, 2008. And it lost that case, and it's been losing a string of these cases ever since then. And sometimes they decide not to appeal. There's a case called Wren v. DC, which dealt with the city's ban on concealed carry that it had for a long time, up until maybe about a decade ago, I believe it was, a little bit over a decade ago, I think was Wren. And the city lost that case, and then they decided not to appeal to the Supreme Court because they were worried about losing at the Supreme Court, which their concerns were correct, proved right in Bruin, but that didn't come until a couple of years later. And so the city made a strategic decision not to appeal to the Supreme Court in Wren. Now that was in the federal district, I believe, not this DC Court of Appeals, but regardless, there's whether the city is going to pursue this further is I think an open question, and one I think we'll have to look into and ask them about. But significant ruling, certainly for anybody who lives in Washington, D.C., I would say.
Yeah, absolutely. And we'll, of course, stay on top of the story if we do, in fact, see an appeal or some other next step in this particular case. But moving on to nearby story in Virginia, related to kind of a similar push to enact, frankly, a similar law among a whole host of additional gun control laws. We have a little bit of new data out this month about what that's doing to gun sales. We have the new both national gun sales numbers, but also particularly relevant for these purposes is the fact that a state like Virginia has sort of rocketed up to the top 5 states for at least new background check data indicating a rush of new gun sales, and it seems to be linked to the legislative push happening there.
Yeah. And this is part of a trend, right? We've seen Virginia in the top 5 for NSSF adjusted NICS numbers. So that's the National Shooting Sports Foundation, which is the industry's trade group. Their report on the National Instant Criminal Background Check System that's run by the FBI, the Federal Bureau of Investigation, if we don't have enough acronyms for you yet. There's also the National Firearms Act is involved here too, that we'll mention in a moment, so the NFA. But yes, according to them, there's been a trend of Virginia hitting the top 5 nationwide in essentially gun sales related background checks, right? Just to talk about the metric here, there is no national registry, right? A national registry is in fact illegal under federal law. So we don't have any way of knowing exactly how many guns are bought and sold each month in the United States. However, we have the background check system, right? NICS. And the NICS checks are required on any gun sale done essentially through a licensed gun dealer to a customer. There are some exceptions to this, like if they're selling to another licensed dealer or something in that nature, but that's a very small percentage of the overall sales. And so, and additionally, gun dealers are the only ones who are allowed to sell new production firearms to the public, right? So it captures quite a lot. There's a long-running debate over exactly how many sales are captured through the NICS system, and that's one of the fights over things like universal background checks. But for our purposes, it's the most comprehensive number we have for how many gun sales happen each month or year or whatever. When you hear someone talk about the number of gun sales, it's generally what they're talking about is the number of NICS checks. And one of the issues with NICS checks is NICS is used for a lot of things beyond just gun sales. They're, for instance, used for concealed carry checks, right? If you in most states, if you go to get a concealed carry license, they will run a NICS check on you as part of that process. And some states, in fact, will recheck all of their license holders. I think Illinois does that every month. So that's several 100,000 NICS checks in Illinois every month that have nothing to do with gun sales. And so you see how it can kind of, if you're just looking at the total number of NICS checks, it can really skew your view on how many sales are actually happening. So what NSSF does is they go through and look at the coding that the FBI puts on their monthly reports for what kind of checks they're doing. And it just cordons off the ones that are sales related. So, in other words, they're filtering out all those NICS checks that aren't related to an actual gun sale. and you get a much clearer view of what's going on in the market that way, and that's why we use their number. But they've had the Virginia in the top 5 really since the election here. I'm in Virginia for those who don't know, and so from December on, Virginia has jumped up into the top 5, and Virginia is only I think, what is it, the 12th most populous state. So it's having these gun related NICS checks, which I'm comfortable saying are gun sales metric, at a much higher rate than it should for its population, right? And in fact, the NFA checks, right, the checks related to NFA items, those really skyrocketed in Virginia to where Virginia was 3rd in the country behind just Texas and Florida for the number of NFA item checks last month. And the NFA checks, all NICS checks were up across the country last month for only the second time in the last 12 months that we've seen a year-over-year improvement. It was 3.5% improvement for the whole country, and then Virginia was punching well above its weight in terms of how many guns people were buying. And then for NFA items, there was this continued like huge surge in that because of the tax cut going into effect, right? The silencer tax has gone down to $0, short barrel rifles and shotguns from what used to be at $200. And so the year-over-year increase in NFA checks nationwide is up 167%. Obviously an incredible number and a clear reason why that's happened. But also, this has had an even greater effect in Virginia, as we talked about. I think it's just the 12th most populous state, but it was the 3rd for NFA item checks, and so. You can really see the effects of politics on gun sales here. A pretty stark contrast, right? Virginia, the change in power of who controls the state government. Everyone knows that new restrictions are coming. We're now in the middle of those restrictions passing through the legislature on their way to a sympathetic governor. And so people are flocking to their gun stores to buy up things that they reasonably believe are going to be restricted in the near future, right? Things like AR-15s and AK-47s, the semi-automatic civilian variants of those are going to be restricted very likely in the near future. The assault weapons ban has passed both houses of the Virginia legislature. They just need to reconcile them now in this crossover period. We talked about this in the podcast with the VCDL's Phil Van Cleve a couple of weeks ago. But you can see the effect of it here, and a similar effect is obviously noticeable from that tax repeal in the president's budget last year, the one big beautiful bill, right? That we've covered extensively, and now you're seeing this real world impact of it. So the takeaway to me is how much of an impact you still can see from politics on gun sales, even in this period where gun sales have, really been flat for the last several years and have been in trending downwards increasingly. Even that you could argue is largely a political. It has largely been influenced by politics because many gun owners view President Trump and Republicans who currently control the federal government as friendly to them and unlikely to enact new restrictions. So they're not, it seems, not as motivated to go to the gun store. But so, those are not the only things that impact demand for guns, but they're certainly significant part of the formula, right? 2020 is a great example, right? You had that political, excuse me, you had the political motivation with the election going on with stark contrast between Trump and Biden, but you also had all of these other factors that weren't directly related to the election, right? You had the murder of George Floyd and then the rioting that followed after that. And of course you had the pandemic and all of the things that were happening at the beginning of the pandemic that made people concerned for their safety, right? meat shortages, all sorts of shortages of everything you could imagine, hospitals overflowing, police getting sick, and being short staffed, and just general chaos. Also, has a huge effect and led to the biggest surge in gun buying of all time. Um, but certainly politics even then was a major part of it, and I think these most recent numbers show it still certainly is today.
Yeah, absolutely. And we'll keep tabs on that, because Virginia is not the only state, as these legislative sessions are proceeding, to see major gun control pushes. It's perhaps the highest profile with the biggest raft of potential proposals, but there are certainly others as well. So we'll be keeping an eye out for that in the future data to come. Moving on to another big story this week that we're just going to touch on briefly for our purposes here, but we're going to get much more in depth on in our interview podcast this week. That is, of course, the Supreme Court hearing oral arguments in its Second Amendment case of the term, the first time in its history that it's had two Second Amendment cases in a single sitting. This one had to do with the federal prohibition on unlawful, quote unquote, unlawful drug users possessing firearms. The case US v. Hemani, involving a Texas man who was caught during an FBI raid of his home with a pistol, as well as about an ounce of marijuana and a little bit of cocaine, but that didn't really come up during the oral argument. It was mostly about his marijuana use, and then a whole host of other drugs, frankly, came up during oral arguments as well. But I think both you and I, we obviously listened to this oral argument. Our immediate takeaway was just a little bit of surprise of how well it seemed to go for Mr. Hemani.
Yeah, and ayahuasca came up, right?
Yeah.
I think it was Sotomayor brought up ayahuasca, and Barrett Barrett called it Sotomayor's drug. Just saying that she brought it up because Barrett had never heard of ayahuasca. I guess she's not a big NFL fan, because I think if you follow the NFL closely, you're aware of ayahuasca because of Aaron Rodgers, who maybe he should have been tuning in. I don't know. Ketamine came up as well, a famous sort of tech bro drug there. But yes, the interesting bit was maybe how much was actually focused on the actual charges against Hemani, right? The actual facts of the case, because he really is only accused. He's accused of quite a lot, right? In general terms, in public, what the DOJ has put into their briefs about him, right, including very timely accusations that he's connected to the Iranian Revolutionary Guard, right? That we're currently at war with, or whatever this is, sort of.
At least.
Yeah, the administration kind of goes back and forth as to whether it's a war every so often, probably because there's serious legal implications to launching a war without congressional approval. But that's well beyond the scope of what we're talking about here. It's only relevant in the sense that Hemani is accused of being connected to the Iranian regime, but not, those aren't part of his charges, right? He was accused of a lot of stuff, of being a drug dealer, of being, basically a terrorist sympathizer. But he was only charged with being a habitual user of marijuana, because he admitted in basically conversations with federal law enforcement after his apartment was raided, when they found a gun and marijuana, as you mentioned, he admitted to using marijuana I think every other day, was what they put in the brief, right? So that's what he's actually accused of, which is not a lot, right? In terms of all the other things the government says it did, what he's actually legally accused of is being a habitual user of marijuana and possessing a firearm. And so I think structurally, going into this case, right, if the focus was more on everything else, Hemani, I think most people viewed him as an unsympathetic defendant, right? A particularly bad defendant to have this type of case heard by the Supreme Court. You'd rather have just somebody who's maybe a medical marijuana user who's using it to help them treatment or something. There's many more sympathetic people you could think of, sympathetic characters, that if you're in favor of having this law struck down, right? If you think the law is unconstitutional or violates the Second Amendment, or weed is not a particularly dangerous drug, right? You'd rather have a more sympathetic character as your test case at the Supreme Court here. But so that, interestingly, that didn't seem to matter at all to the justices, which, like, it probably shouldn't, right? It's not part of the case, but they didn't take like a broader view of Hemani's dangerousness. They really zeroed in on the actual drug use itself. And in fact, most of the examples, the hypotheticals that came up, like the ayahuasca and example, ketamine or whatever, most of the examples that came up went the opposite way and talked about even more sympathetic potential hypothetical people, like somebody who uses Ambien off script, right? Or even somebody who uses it on a prescription, right? Because a lot of the way the law is structured, there was a lot of questioning around, well, is it the fact that the person is using the substance that makes them dangerous, or is it just that they're breaking this law that's the issue, right? Do these substances that are on the schedule, is there some determination that the use of them makes somebody dangerous? That was something that Barrett focused a lot on, right, for instance. And so really a lot of the hypotheticals were around like, well, what if somebody uses a weed gummy, once a night or whatever, and or what if somebody smokes weed at a party, but when their gun's not around, and then they come home, like, why is that person dangerous? Why is the Second Amendment not implicated by their use, or by taking away their gun rights? And so, yeah, it seemed to go really well for Hemani. I think surprisingly well. I think you had a couple of key quotes in your piece as to that illuminated that, right? For instance, you had one from Justice Barrett where she said, quote, is it the government's position that if I unlawfully use Ambien or I unlawfully use Xanax, then I become dangerous? What is the government's evidence that using marijuana a couple times a week makes someone dangerous? Which, if you know about Barrett's history with Second Amendment jurisprudence, that's been one of her major focuses, is this idea of dangerousness, that you can disarm people, that the government can disarm people if they're actually dangerous, but not necessarily otherwise. Like, there has to be some, that's what the history suggests. But yeah, I mean, it seemed to me that 6 or 7 of the justices were very skeptical of the government's position in this case overall. Now, the other interesting thing, right, is that they went 2 hours, nearly 2 hours again, which is not normal, right? They think they do an hour for oral arguments, and every one of their Second Amendment cases since Bruin has been, including Bruin, has been sort of a marathon oral argument, right?
Yeah, certainly. It was a very extended oral argument, like you said, leaned mostly towards skepticism of the federal law, at least as applied to this particular defendant. But of course, like I said, we'll get much more in depth into the weeds. We're going to have David Kopel on, who's a Second Amendment expert and law professor and has been a longtime Second Amendment scholar. And he's going to be joining you on the interview podcast to sort of dive into those weeds. That'll be out for members on Sunday and then available for everyone else on Monday. So folks should check that out for sure.
Yeah, and we'll definitely get into the weeds of what the justices were doing. One of the interesting bits, though, that you should talk about, because you had an analysis piece on this, is, I mentioned 6 or 7 seemed sympathetic, which implies that Hemani has a good chance of winning. And I think that was both of our takeaways. However, something to consider here is the 2 that seemed unsympathetic towards Hemani and much more sympathetic towards the government, right? Because of who those 2 are. That's what makes it interesting, which is we had Chief Justice John Roberts expressing quite a lot of skepticism towards Hemani's lawyer. In fact, only questioning Hemani's lawyer, didn't question the government at all. And then you had Justice Samuel Alito, maybe less surprisingly, very skeptical of Hemani's argument and very concerned about where this could all lead as far as drug users go, with allowing them to have firearms. And so that's interesting, right? Because even though most of the liberals, right, the three liberals all seemed to be more skeptical of the government's position than Hemani's in oral arguments, to varying degrees, right? But they all had questions that were pretty probing of the government and its position. Even Jackson, right, who was kind of, she still was getting her shots in at the Bruin test overall, but she kind of was additionally taking shots at the government for having sort of a hypocritical view of the Bruin history test in her estimation, it seemed. But with Roberts and Alito potentially going against Hemani and in favor of upholding this gun law, there's some reason to think you could get they could get the liberals on board, right?
Yeah, well, just from a strategic point of view, right? If you have two conservatives already pretty firmly signaling they're not going to vote for this, that leaves a 3-vote shy of a majority there, and there happen to be 3 liberals on the court, and none of the 3 have ever voted in favor of a Second Amendment challenge in a single case that the court has ever heard. I mean, you could kind of make the case for Caetano. We put that in the piece because that's really just a unanimous per curiam opinion that was just very brief, and all it said is essentially that, hey, don't forget Massachusetts Supreme Court, Heller exists, and Heller says that modern weapons can still be covered by the Second Amendment. So it's not even really like a substantive Second Amendment ruling. But beyond that, they've never once.
It was a one-page opinion. Well, there wasn't a lot to say Tano, but two of the 3 liberals were on in the majority, in the unanimous per curiam for that. But generally speaking, right, they've been very unhappy about the Bruin test, especially Jackson, but all of them either voting in the minority, against it when it happened, or subsequently spending quite a lot of time talking about how they don't like it, which is what Jackson's doing, even in this case. So there's strategically, if they could find some common ground with Roberts and Alito here that weakens the test, maybe they'll do it, right?
Yeah, and that's just it's just a live possibility, especially because the rationales that Roberts and Alito were articulating, especially about deference to the judgment of Congress and the judgment of the DEA, for instance, when it chooses to schedule drugs, that sort of deference to those judgments is kind of at least been one of the big criticisms that these liberals have had of the Bruin test, is that they feel like it takes away all deference to those people, at least in the modern sense, because you have to look to what founding era policymakers thought. And so it's just an idea, it's probably not the most likely outcome, but it's something that at least is underrated, and I think folks should take seriously, particularly because all of the justices seem to have so many different reasons for why they were at least curious about this particular law. I think there's a lot in the air as to where things shake out.
Yeah, this is another case where it seems like they're not all on the same page at the very least, right? And so you might get another majority opinion that's I think it'll come down to who can best narrow the decision to get the most people on board. If Roberts and Alito can get a holding that the liberals come over to because they like how it strategically weakens the Bruin test, maybe they'll do that. Look, they didn't signal that in oral arguments. They signaled the opposite, right? They signaled a lot of skepticism of the government's position here. And so I definitely, I will say there is a bull case. That's sort of the bear case. I think for both of us, we think it'll probably be 6 or 7 in the majority, siding with Hemani to some degree, at least. Exactly how broad the holding will be is less clear. It might just be about the fact that the government never even really determined, the Congress never even really tried to determine that smoking marijuana a couple times a week makes you actually dangerous. And so they go with something like that. But maybe Alito and Roberts can come up with some narrow ruling that they can live with that gives more deference, like you were saying, to the government and the executive branch to determine who's dangerous on a categorical level, not just an individual level. And the liberals come over to that. I don't know. I think there is the bull case. There is a bull case where you could see 8-1, 9-0 on a very narrow reading that's probably just tailored to Hemani as applied to him in the on the facts pled in the case, which is just that he smokes occasionally, to a couple times a week, not occasionally, I guess, but a couple times a week. This drug that's not shown to make people particularly dangerous, right? So, and it wasn't like he was arrested while intoxicated with a gun. It's just that he smokes. He admitted to smoking on a couple times a week. So, it sort of depends on how you think some of those responses, especially to Roberts, whether or not you think they convinced him. He doesn't necessarily. Most of his questioning is pretty skeptical, but he gets, I think, to a point where you wonder if the attorney for Hemani was able to put together a cordon off enough case, like a narrow enough argument that she might still be able to get Roberts and Alito even on her side in a very narrow as applied ruling. We'll see. I think, like you said, both of us believe it's probably going to be more like a 6-4, 7-2 ruling in favor of Hemani, but the ultimate point here is to not necessarily totally go off of what these justices say you could look at Thomas, right? He didn't say a lot of anything. Like, he normally doesn't say a lot of anything, but I don't think anyone believes he's gonna side with the government in this case.
Right.
Maybe he will, but it would be very surprising, right? He was the one in the 8-1 decision in Rahimi where he thought they were being too overly broad in their historical analogs in Rahimi. So I think it'd be hard for him to agree that the habitual drunkard restrictions at the founding are akin to this restriction on somebody being able to own a gun because they occasionally smoke weed.
Yeah, certainly hard to imagine.
And then we'll have Kopel on. David Kopel will be giving us, his particular insight in this, because he's been very influential in this area, both in the federal courts writ large and at the Supreme Court in particular.
All right, but getting into some of our newsletter links for the week, we want to do a little bit of a brief update on a newsletter segment we did actually last episode, and that was this new gambit you've seen in West Virginia by gun rights advocates to try to find a way around the so-called Hughes Amendment's general prohibition on machine gun sales to civilians. The Hughes Amendment, of course, limits the legal supply of civilian machine guns to those that were only in circulation prior to 1986. Everything after 1986 is technically illegal, although some gun rights advocates think they may have found a way around that by using a provision in the Hughes Amendment that exempts that machine gun ban to transfers and sales done by state authorities. And most people assume that is, of course, to allow National Guard units, police officers, government entities to continue using machine guns in their official duties. But some folks, Gun Owners of America actually got involved with some lawmakers down there and drafted language that would set up a state agency in West Virginia that would be in charge of procuring new machine guns and offering them for sale like a normal gun to the civilian populace. And at least in their reading, that fits under that exemption and would be legal. Now, we have a bit of an update on this. We talked about this idea being introduced last week. It certainly looks like
you actually wrote a whole analysis piece on this that kind of looked at the legality of it, or the potential legal fight here, because it's an interesting idea at the very least. If you look at the language of the law, you can certainly see where GOA is coming from, even if it's likely to face significant pushback in the courts if it were to pass. But you also, I think more importantly, looked at the political challenge, right? And you concluded it was going to be a hard lift, even in a place like West Virginia where they almost don't have Democrats anymore, right?
Right, yeah. It is one of the most Republican-controlled states in the country, if not the most. I don't know if it is the most, but it's up there.
Yeah, and so even with the party, the more pro-gun party, well in control of what's going on in West Virginia, it's still, for a number of reasons that you pointed out in your analysis piece, a pretty heavy lift to get the state to basically have the police sell machine guns to the public. That's essentially what this would do, right?
Yeah.
And so but that's where this new update comes in, right?
Yeah, we now have an update. Like you said, my read at the time was clever politically, maybe gray area legally, politically probably DOA. And sure enough, it actually made it through one committee. It made it through its first committee stop, did not make it through its second committee stop, and it will not become law, at least this session. So certainly, maybe seems to align with sort of the political challenges that we identified it potentially facing. I'm sure GOA will push for this to be brought back in a future session. Maybe things will change after years of trying to, move the Overton window, but it's definitely not going to become law this year.
Yeah, I mean, definitely one of the challenges they faced was the timing of it, because it came in like right at the end of the West Virginia legislative session. I don't know if that was maybe that was a strategic choice by GOA and their Republican allies there, but that's a hard thing to do right at the end, is bring in a radical new policy like this, gun policy innovation. We talked about sort of the compromise policy innovations on the interview podcast last week. This is another gun policy innovation, much more on the pro gun side, certainly. And I think it even, the timing and the questions around the legality of the bill also led to some internal disagreements in the gun rights movement in West Virginia. Because I think the WVCDL, the West Virginia version of the Citizens Defense League, right? They had showed some opposition to this on social media as well. So maybe there is, I think, still a possibility that they can regroup, like you said, and come back next year, because one of the other things you wrote about in your piece was why this is not necessarily a crazy idea to think this could pass, because in places like West Virginia, you still have a lot of pro-gun politicians who want to do things to show their, to show their bona fides, but they don't have a lot of policy areas left to go. And so, a new thing like this has some potential.
Yeah, it's like the reverse California problem, right? California has passed every gun control policy you can think of under the sun. And so every year it seems like they're introducing a brand new policy that no one's ever even heard of, because they're always looking for a new thing to show that they're doing gun safety legislation or whatever they might call it. And it's the same thing in red states like West Virginia. It's like, well, we've done constitutional carry, we've lowered the age to purchase, we've gotten rid of all these gun-free zone impediments. What else can we do to show that we support the Second Amendment? And someone hands them a new innovative new policy that no one has tried before. And that's the exact kind of thing that a lot of these, safer seat lawmakers in these states are looking for.
Yeah. And honestly, that's the dynamic I think that's going to be the biggest challenge for the group that we interviewed last week on the interview podcast, the Bridging the Divide group, because the impulse in American politics at the state level around gun policy is to move even further into that polarization, to what has this plan to have the West Virginia State Police sell machine guns to civilians, I think has a better chance of passing, or plan to confiscate all of the magazines, that hold more than 10 rounds in Virginia, like that plan, even though that got defeated as well. Those two policies, while polar opposites of one another politically, I think have better chance of passing than these compromise policies that were discussed last week in this current environment as things are now. That's what you see. Like you see the states diving deeper into the polarization, not the other way around. Now maybe that changes. Maybe this group that we interviewed can have an impact on the debate, but that's where the momentum has been recently. And that's why I think a policy like this, even though you sensibly pointed out what the reality is today, you also talked about why this sort of proposal is not, pie in the sky kind of thing. Like there's a real chance it could pass. And then if it does pass in West Virginia, there's a good chance it could spread to other similarly deep red states.
Yeah, you've already seen a similar bill introduced in Kentucky. I think it only had one sponsor in that case, so I wouldn't be hopeful for that one to go any further than the West Virginia one bill did. But you've already seen the impulse to spread it to
Yeah,
other
it
states.
takes time for these things to propagate, but once they get hold in a state, the gun policy was usually they start showing up in other similar states with similar politics.
Yeah, absolutely. But speaking of politics, we do have a political update. This week, we saw pretty major primary elections in the state of Texas. Uh, and a couple of races in particular have to do with guns. Obviously, the big Senate primary race between John Cornyn, incumbent Senator John Cornyn, and current Texas Attorney General Ken Paxton. That's also partially to do with guns because Cornyn was seen as instrumental in the passage of the Bipartisan Safer Communities Act. And so a lot of more
Yeah.
right-wing
was.
members of the Republican Party sought to primary him as a result of that. That race has gone to a runoff. A similar situation in a congressional seat, obviously, we've talked about this race in particular before, was incumbent Representative Tony Gonzalez, who I think voted for the Bipartisan Safer Communities Act. He has fielded a primary challenge for the last year or two from famous gun tuber Brandon Herrera, the AK guy. Has not been successful in years past. Brandon Herrera is again challenging Gonzalez in that primary. That was set to go to a runoff, and we just, as of late last night, got an update that Gonzalez will be dropping out of that race, which essentially hands Herrera the nomination.
Yeah, these were the two races, honestly, nationwide where you saw significant pushback to the people who backed the 2022 bill, the Bipartisan Safer Communities Act, which did things like add new groups to the prohibited persons list. It expanded the domestic violence prohibitor, right, to dating partners, not just people who are married or related or living cohabiting, living together. And then it also put in place a stricter background check process for 18 to 20-year-olds as well. That included an additional 10-day window that gun sale could be held up for that group while an investigation is completed. So these were the two races I think that you saw a lot of the primary action against Cornyn and Gonzalez was centered on that fight. Now, obviously, the Paxton Cornyn race has become about a lot more than that, and even the Gonzalez Herrera, every race is about more than just one thing. But
Right.
That was certainly the impetus for why Cornyn got so much backlash inside of the Texas Republican Party. He was booed at a convention at one point over this. And then that was definitely the main reason that Herrera says he challenged Gonzalez. Now, he initially challenged Gonzalez in 2024 in that election, and went to a runoff but lost to Gonzalez, and then Gonzalez went and pretty easily won the general election in 2024. This time around, same matchup again. Herrera did a lot better in the first round of the race. Texas, if no candidate gets to 50%, they do this runoff. So it was a runoff. Herrera got more votes than Gonzalez in the first round by I think about 2 percentage points, but he didn't get to 50%. So it was going to go to runoff. However, for anyone who hasn't been following this closely, something well beyond gun politics intervened here to decide all this. Essentially, Gonzalez was involved with one of his staffers and had an affair with her, and then she killed herself by setting herself on fire, I believe is the reporting. So pretty horrific situation. He denied it for months, I believe, and then after this most recent election, he admitted to having the affair, and it has now, as of last night, said he won't seek re-election. He's going to stay in his seat. He's not going to resign because that would cause a lot of problems for the Republicans who currently control the House by the thinnest possible margin. And if they lose anyone from their caucus, I think it becomes kind of a free-for-all. Like they probably would lose the majority control. Like Johnson wouldn't be speaker anymore, most likely, in a scenario where Gonzalez left immediately. Instead, he's going to serve out his the remainder of his term, and then Herrera is now going to be the nominee. Now, for us, it's a little complex, right? Because it's not Herrera didn't defeat Gonzalez. He might have defeated him anyway in a runoff, right? He was ahead of him in the four-way race for the first round, but he didn't defeat him based on gun policy, right? So I don't know, but he is still going to be, I think, very much the gun guy, right? If he doesn't win this general election, if he wins the general election, maybe that becomes a political lesson. This is why we've been following this race, right? GunTuber launches a campaign against a Republican over gun control, like over his being upset with Gonzalez voting for this gun control bill. And so the political narrative is mostly around gun policy, which is not very common the last couple cycles when it comes to our federal elections. Not a lot of them have been fought on this, with guns being the primary issue. They're always an important issue, but rarely the primary issue. And so in this race, that's why we focused on it. And he lost the primary last time around, although he did really well for a first-time candidate, frankly. He was doing even better this time because I don't think he got into the 40s the first time around in the first four-way, five-way candidate race. And he was the leading candidate this time around, though he didn't get to 50%. But now the race is warped into, obviously Gonzalez didn't necessarily lose because of his gun vote. Now, and another key thing about this district is that it's where Uvalde is. So that adds another layer of gun politics to the whole situation. But now Herrera is going to be the Republican candidate for this district. Gonzalez won comfortably in 2024 in the general election. He won 62% of the vote. However, in 2022, he only won 55%. So I don't know. It could be a close race there, and we'll have to see how that plays out. I think there's probably more risk that if Herrera loses, it'll be pinned on the fact that he is a big gun. Like, that's his whole persona, is that he's a gun tuber guy, right? That's why he launched his campaign. And now if he wins, you could maybe still try to make the case that connects back to his gun activism, but because again, it is kind of the main thing about him. But if he loses the general election, because it's going to be a tough year for Republicans 2026 as far as all the polling indicates. Now I don't know. The other question is, like, how does Texas redistricting affect the district? I don't know if it makes it more competitive or less competitive than it's been. But regardless, Herrera, I guess one of the top line things here is you have a gun tuber who's going to be the Republican candidate in a district where Republicans have been winning. So he has a good chance of becoming the first gun tuber congressman, I guess, right? So that's another thing to not overlook as well. But yeah, interesting situation.
Yeah, and certainly for our purposes, that's why, like you said, even though this particular runoff or this primary didn't really hinge on gun policy, it's still totally colored by gun policy because of who he is, why he got into this attempt in the first place, and ultimately what the ultimate result will be and who holds that seat come November will still, I think, have at least some gun policy implications.
It'll be interesting to see if he does get in Congress, how he acts, if he just becomes another generic Republican. They're all vaguely pro-gun, right? But some of them are much more willing to buck their party than like Thomas Massey, somebody like. Is he going to be a figure like that? He hasn't run like a figure like. He's much more of a pretty normal Trumpy Republican is what I would say at this point. I don't know. Maybe I haven't followed everything he does. But that's what he strikes me as somebody who was to the right of Gonzalez on pretty much everything, not just on guns. And it'd just be interesting to see how somebody like that, a figure like that, would actually operate in the world of party politics of Congress. Does he just become another sort of backbench votes party line on everything Republican, or is he The fact that he's got some level of built-in audience, does he become one of your more media obsessed politicians, or more radical? I don't know. It's something we'll pay attention to for sure. I don't mean to sidetrack us too much on it.
No worries. I think that's all we've got for this week.
Yeah. So
blurry there.
Well, yeah, and I don't know. It's an interesting case, and I'm sure a lot of our audience knows who Herrera is. So, and they have a lot of whatever opinion they have of him, probably relatively positive one, because if you're watching this on YouTube, you are probably getting AK guy videos or whatever. But yeah, so it's just interesting personality wise as well, what it all means. But anyway, I didn't mean to get so sidetracked on this, especially because the Gonzalez resigned. He didn't beat Gonzalez because of the gun stuff. Gonzalez is dropping out because of his horrible personal life. So that just sort of throws a little bit of a wrench into the whole easy calculus of looking at this race as upstart gun rights activist versus establishment Republican, or whatever you want to call it. So makes the analysis harder. So I don't appreciate that, Tony Gonzalez. You should have been a less horrible person so that the political analysis would be easier for us. Anyway, I give that advice to all politicians.
Yeah.
It'd be our jobs would be easier if it was all just everyone lining up their policies against each other and not having to think about the rest of it. But that's not how real life works. Anyway, yeah. You're up in the mountains this for the foreseeable future here, right?
Yeah,
and you guys are getting a blizzard, right?
Yeah, viewers might recognize I'm in a different background. I am up in the mountains of Colorado, staying at my in-laws' place because there's a whole bunch of pretty nasty maintenance work going on in my apartment building right now. And I probably could have stuck it out, but it would have made recording podcasts and doing all manner of other work there pretty difficult. So I'm up here, and yeah, we're actually, as we speak, supposed to get up to a foot of snow. We'll have to see. It's been a pretty mild winter here in Colorado, almost alarmingly so with how little snow we've gotten. So we'll see if we get the full foot. We certainly need it.
Yeah, you've been the opposite of us on the East Coast this year. The East Coast has been getting all the record cold and tons of snow, and then Mountain West and West Coast have all been in long dry season, really warm seasonally. So good luck with the snow. I'm sure hopefully you'll be able to enjoy it a little bit if you're up in the mountains, but hopefully it doesn't cause too much of an inconvenience for you. I know you guys know how to handle the snow a lot better than we do here in the mid-Atlantic, but good luck to you either way. I don't think I have anything big coming up this weekend. So maybe I'm sure my wife will have things for us to do, probably plant-related things around the apartment, but so I'll look forward to doing that with her. But yeah, I guess that's all we've got this week. A pretty boring as far as what we're going to be up to, but pretty big week for news, though. Anytime the Supreme Court is hearing a Second Amendment cases, we've emphasized over the years, it matters a lot because they just don't do it that much. The jurisprudence is so thin on it. There's only been 7 gun cases. There's not gun cases, Second Amendment cases, I should say. They've been doing a lot of gun cases, but most of them haven't been Second Amendment cases. So anytime they do that, we always want to dig in real deep. So that's what we're going to do on the interview podcast this week. So make sure you guys tune into that. I've been dragging this along too long here, so I think we're going to end it. That's all we've got for you guys this week. If you want to keep up to date with what's going on with Guns in America, head over to thereload.com, sign up for our free weekly newsletter. And if you want to support the work we do, please buy a membership to get exclusive access to hundreds of pieces of analysis and reporting you won't find anywhere else. That's all we've got for you this week, and we will see you again real soon.
No, the devil's got no